Well, hello and welcome to another episode of the Legal Gym podcast. Thank you so much for joining me today. Today we're going to be talking about the main reasons, and there's two of them, that most trademark applications will get denied, as well as what you can do to help avoid this happening to you. For the show notes for today's episode, which will include all of the links and resources for everything that I'm going to be talking about today, make sure you head on over to hawthornelaw.net/18. All right, now let's dive in. Now, before we get into the amazing, fabulous content for today's episode, I want to let you know about a new training that I'm working on. I'm going to be teaching my 4R framework to get your trademarks registered quickly and easily. In addition, I'm going to be sharing the top 3 mistakes that I see online entrepreneurs make that can sabotage their brand and even force them into bankruptcy. So if you want to sleep better at night knowing that your brand is protected, you definitely do not want to miss this training. Just head on over to hawthornelaw.net/trademark to get notified when the training is live. Once again, that's hawthornelaw.net/trademark. And don't forget, everyone who attends this training is going to get a free gift. So if you are an entrepreneur who is building a brand online, this is one training you definitely do not want to miss. One more time, go to hawthornelaw.net/trademark to get signed up for the notification list today. All right, as an online entrepreneur, you want to make sure that your brand is protected. And you know that the only way to ensure total and complete protection of your name is to file for federal trademark protection. And although filing a trademark is deceptively easy, the application is very simple to fill out. It is also deceptively hard because there's a lot of little nooks and crannies in the application, and if you don't know exactly what you're doing, you can very easily mess it up. And if you mess that up, you could waste a year or longer on a trademark application waiting for that mark to register, not to mention all the legal fees and filing fees that go into filing that application just to have your application get denied. So today I want to share with you 2 of the main reasons that most trademark applications get denied. We're going to go through these in a bit more detail, but for right now, I just want to let you know the first one is that your mark that you're using that you want protection from is overly descriptive. We're going to talk about that here in a second. And then the second reason, and this is the more common reason that most trademark applications get denied, is for what's called likelihood of confusion. And so let's start with the first one, overly descriptive. Now, I've talked about this before on the podcast, and basically an overly descriptive mark is a trademark that you're using that basically describes exactly what you're selling. So if you were to open up a store that sells dog food and you called it the dog food store, unfortunately, you're not going to be able to register that mark. Or if you open up a store that sold apples and you wanted to call it the Apple Store, also would not work, aside from the fact that you might also get a likelihood of confusion denial, but we're going to talk about that here in a second. So the first thing I want you to understand is that you cannot register a trademark that is overly descriptive. In other words, it is basically describing exactly what you're selling. If you try to do that, your trademark application will get denied. Now, I will tell you, there's some gray area here, and there's a lot of marks that the trademark office will say are overly descriptive that may also be considered suggestive. I recently had a trademark filed by a client, and the trademark office denied the trademark. They said it was overly descriptive, but we did file a rebuttal, and we were able to overcome that denial and get the trademark registered for the client by arguing that the name was actually suggestive and it was not overly descriptive. Just because you get an overly descriptive mark does not necessarily mean that your application is fatal. It means that you're going to have to do some work to overcome that denial. And sometimes that can happen, sometimes it can't. But that's the first thing I want you to be aware of. You cannot have a name that's overly descriptive of what it is that you're selling, whether it be a good or a service. Now, the second main reason that trademark applications get denied is because of what's called likelihood of confusion. And a good example of this is a case that's right now making its way up and down the appellate court system, and it's Jack Daniels versus a company that manufactures a dog toy. And the dog toy is called Bad Spaniels. And so it's basically a dog toy that's made to look like a bottle of Jack Daniels, and it's got all sorts of parody words and things on it. It's right now going up and down the appellate court system. The Supreme Court recently denied cert, meaning they weren't going to take it up. Right now, the dog toy is actually winning over Jack Daniels. We'll see what this goes. It's, as of yet, it's still unsettled, so I'm not sure which way this is going to go. But let me just explain what a likelihood of confusion denial means. It basically, a likelihood of confusion exists between trademarks when the marks are so similar and the goods and or services that are being sold by the applicant for which they are used are so related that consumers would mistakenly believe they come from the same source. So basically, once more time, the trademarks are so similar that the goods and or services for which they are used are so related that consumers would mistakenly believe they come from the same source. So when you're looking at this and you're doing the analysis, a lot of times a lawyer will be needed to do this analysis, but you can look at this yourself as well. It's not rocket science here. The first thing you can look at is the sound, how the word actually sounds when it rolls off the tongue. So you could have two different words that are spelled differently but sound exactly the same. This is why I tell people that when you're doing your comprehensive search, you want to not just look for words that look the same, that are the exact same words. You also want to look for phonetic equivalents of that word, and that's really important. So if you've got two words kind of like no and no, like N-O and K-N-O-W, those are two words. They do not look anything alike, but they sound exactly the same. And so the same can be true of a lot of different trademark names. You might have two trademarks that, although the marks look completely different, they sound exactly the same or very similar. And that could cause a likelihood of confusion denial. Another way to look at this is the appearance of the marks. Now again, you might have two marks that look the same, but one uses a stylized font, and that's the way they registered it, and one uses just regular font. That also is going to cause a likelihood of confusion denial. And then the last thing that you need to look at is the commercial impression. So the marks could include some of the same design elements within them, and by doing so, they create a similar overall commercial impression, even though one of them is registered and might look a little bit different than the other one. If they look in general like they're coming from the same source, then that's going to cause a likelihood of confusion denial. It's important to understand that the similarity of the marks is not where the analysis ends. You also have to look at the goods and services that are being sold under those marks and determine whether or not they are related. So even if two marks are found to be confusingly did I say that right? Are found to be confusingly similar, you will not get a likelihood of confusion denial unless the goods or services upon which or in conjunction with the marks are used are in fact related. So basically that means you have to be selling goods and services in the same industry and the same types of goods or services for there to be a likelihood of confusion. If you have two marks that are exactly the same but they sell in completely different industries, then there is not going to be a likelihood of confusion. Now, it's also, you need to understand, sufficient that the goods and services are related in such a manner that consumers are likely to assume that they come from the common source. So it always goes back to what is the consumer going to see. If the consumer sees two marks and they're selling goods and services that are similar, then if it seems like they might come from the same source and a consumer, it's reasonable for them to believe that that is the case, then there will be a likelihood of confusion denial. So let me give you a couple examples. You could have some goods that are being sold under a trademark, and maybe on one mark they're selling t-shirts and pants, but they're not selling hats, and on the one that's applied for, they're selling hats. Well, a consumer might look at one that sells t-shirts and hats and the other one that sells just hats and say, oh, well, the one sells clothing, this is a hat is a piece of clothing. It's likely that they will be confused as to the source of those goods. In terms of services, if you have one mark that's selling banking services and another one is selling mortgage lending services, again, it is, even though those aren't the exact same services, is it reasonable to believe that a consumer would think that those marks are coming from the same source or that those goods and services are coming from the same source? Yes, that is reasonable for a consumer to believe. So another example would be if we're looking at goods and services. So if you have one brand that is selling t-shirts and pants, another brand that is selling an online retail clothing store, or is providing an online retail clothing store, I should say, that is another example where you could have somebody who's looking at those two marks and could rightfully believe that the source of the goods was the same vendor. So those are all situations where if you have marks that are similar in sound, similar in appearance, similar in commercial impression, and the goods and or services that are being sold under that mark are in related fields, and it's likely that a consumer might believe that those goods or services come from the same source, then there's going to be a likelihood of confusion denial. So how do you make sure this doesn't happen to you? And I realize the analysis here is complicated, it's tricky, it's complex. Well, on the one hand, you can hire a lawyer And whenever we do whenever a new client comes on board for us for our trademark services, we do a comprehensive search and we look for all these things and to try and determine whether or not there is going to be a likelihood of confusion between our clients' trademark and any prior filed or registered trademarks that are already out there in the market. So that's the first thing we're going to do, is do a comprehensive search. So you can do a comprehensive search on your own. If you're confused about what to do or how to do it, then make sure you get legal help and have a lawyer or a law firm do that search for you. It's well worth your money to hire them to do that. And then obviously the second thing you want to do is you want to make sure your name is not too descriptive. And oftentimes you might need a lawyer to do a search to help you determine whether or not your name is descriptive, because oftentimes what I will do is I will do an initial search of a name, and it's funny how many times the name that my client is applying for will actually show up in the search results. I can look at that search result and see what happened with that mark. And if it's a dead mark, in other words, the application is not still pending, I can see why it is not pending anymore. And I actually have found marks that are very similar or the same to what my client is filing that died because they got a descriptiveness refusal. In other words, the trademark office said these marks are too descriptive. So that can be very helpful and very telling if you are trying to register a mark that is very similar or the same as that other mark. If it was denied for because it was too descriptive, then good chance that your mark is also going to get denied because it's too descriptive. So that's just something to think about. You want to file your trademark application, and you want to have as much confidence as possible when you file that application that your mark is going to get registered. And the only way to do that is to do this analysis and make sure that, number one, your trademark that you're filing for is not overly descriptive, and number two, that it's not likely to be confused with a prior filed mark that's already been registered with the U.S. Patent and Trademark Office. All right, you Legal Gym listeners, now that you know more about why trademark applications get denied, you are ready to implement. Because if there's one thing we love to do over here at the Legal Gym, it's to take massive action. So if you haven't already, make sure you check out the show notes page for today's episode. You can get a rundown of all the links and resources that we talked about here today by visiting hawthornelaw.net/18. In addition, if you're interested in learning more about how to legally claim the rights to your brand name, then you'll want to schedule a free branding strategy call with me. That's right, for a limited time, I'm offering a free strategy call to talk with me about the branding for your online business and how to make sure it is legally protected. So if you'd like to learn more, head on over to hawthornelaw.net/TM-video. I know that's a mouthful. I'll say it again. That's hawthornelaw.net/TM-video. And on that page, we have lots of great information about the process of protecting your brand so that you don't have to worry about getting a cease and desist letter or being forced to rebrand your business. Once again, that website is hawthornelaw.net/TM-video. Thank you so much for listening, and I look forward to seeing you or talking with you on the next episode.